Hey everyone, this PowerPoint will cover content from Chapter 9 in the textbook on courts. So what we're going to be talking about in this chapter are the basics about how the American court system is structured and how it works, and the people who work in the courtroom on a regular basis. But before I start, I always like to talk about this. Some of y'all probably recognize Lady Justice, or also known as Justicia. And this is a symbolic representation of the court system, but also of the criminal justice system, but specifically the court system in the United States. And even though most of us will recognize it, we haven't put a tremendous amount of thought into it, what it means, why it's important, or what it's trying to communicate through these symbols. And so that's why I wanted to talk about it. Sorry, I've got a bit of a head cold I'm getting over, so if I sound weird, that's what's going on. Anyway, so when you look at the image there of Lady Justice, you'll see, most people recognize the scales and the sword and the blindfold immediately, but there's more going on here. So what is the blindfold about? Well, it talks about objectivity, which means that you try to weigh all of the evidence, you try to look at all sides of the case, you try to look at the facts objectively without bias, prejudice, fear, or favor so that you can reach a fair and just outcome. The scales represent balancing truth and fairness, also weighing the facts of both sides of the case. And the sword represents the concept of rule of law and the consequences for violating the law upon which she stands. So she stands on a book, and that book is considered a law book, which represents that idea of rule of law, that in our society, that is the foundation for our system of government and of justice. And that's why she stands on that foundation. So keeping that in mind, we look at the history of the courts. So throughout human history, as far as recorded human history, we know societies have had a variety of methods that have been used to resolve interpersonal disputes and violations of social norms and values. That's essentially what the court system is. It's a formalized mechanism through which a society can settle disagreements without, fighting or combat or vengeance and things like that. That's the goal of having a court system. And so the US court system, just like policing, evolved directly from the English court system. And the English court system replaced the less formalized methods I just mentioned, like vengeance and the blood feuds. So blood feuds were essentially times where a party was harmed in some way, and it was on the family of the victim to go and seek justice on their own. And a lot of times they would go and seek justice, but they would be excessive in how they sought justice. And so the family of the other person thought that that was unjust. So then they would go seek vengeance on behalf of their family member or friend. And it would go back and forth for, indefinitely, sometimes years or decades in some cases, where they would fight and kill each other in an ongoing back and forth. And the English court system was trying to replace that. Another method, which kind of harkens back to some of the things we talked about in the past with the pre-Enlightenment era, was the idea of trial by ordeal, which I think I mentioned, what was that, chapter 3 or 4 or something, where it was believed that God would intervene on behalf of an innocent person, and so they would put you through some sort of horrible test, like or sticking your hand in boiling oil or whatever, and if you survived, or you survived with minimal injury, it was assumed you were innocent because God protected you, because that's God's way of making sure justice is done. And then there was the idea of trial by combat, where you would fight. It was kind of an extension of the vengeance concept, but it was more of a controlled battle between the aggrieved parties, kind of like a duel sort of thing. And then as time progressed, it became more formalized and people could hire others to fight on their behalf. And so you would have professional warriors basically who would engage in combat to settle disputes. And this is actually what ended up evolving into our court system. And that instead of fighting it out physically in a in a in an arena, you have two parties fighting using facts and the law inside of a courtroom. And that's why we'll talk about it in a minute. It's called an adversarial process. There are two adversaries basically combating one another, except through information and guided by the law. The English courts were also important for implementing the common law. So prior to the development of a common law in England, each location, each community or city or whatever would have their own kind of unique set of laws and rules. And over time, it became apparent that that was not very effective as England grew and became more populated and more interconnected. The king recognized that we needed a more, or they needed a more uniform code of laws and ways of enforcing that law. And so the king created the common law, which meant that it was a single legal system that was common to the entire, British kingdom or English kingdom at the time. And so the assumption was with that, that if you have a common law that should apply the same way across the entire kingdom and apply to everybody in the same manner, you needed judges who could apply this common law and interpret this common law in a uniform manner. Okay, and this is all really the foundation of our court system and how our legal system works in the United States. So what does the court do? I've already mentioned that, it's a formal method for settling disputes between individuals, right? But ultimately, the role of the court is to do justice. And this is an important thing because there's a tendency for us to talk about justice as kind of an outcome that, oh, well, I get justice through the court process. And let's take a criminal case. You are harmed by a person, they are criminally charged, they go through the court process, they're found guilty, and they get punished, and that's justice under most people's concepts of what justice means. But in reality, the way the court system is supposed to work is that the justice happens through the process itself, and the outcome doesn't matter as much. The issue is that we want to make sure that the process is fair and equitable and follows the rule of law, which is all those things that Lady Justice represents. Oh, just talked about that. So how this is done is through the application of due process rights and legally required procedures, so procedural justice, that things have to happen a certain way and the law has to be understood and applied and interpreted in an accurate manner, things like that. That's where justice really comes from in our system. And the reason we do that is because at the end of the day, there's a high likelihood that someone's not going to be happy with an outcome of a trial or a criminal case, and so they're going to feel like justice wasn't served. And that's why kind of the court system takes that out of the hands of the individual and puts it into the process itself. And as I mentioned before, this is accomplished through an adversarial process where you have competing parties, and it really shouldn't be competition, but it is. You'll have the plaintiff and the defense. In this case, it'll be the state. In criminal cases, the state is the plaintiff, and they bring charges against the defendant. They have people to represent their interests, and they use facts of the case and arguments and logic and whatever to argue the merits of the case on both sides, and it's guided by the law. And that's the rule book everybody follows. And at the end of that, whatever the outcome is assumed to be a just outcome because that the process did what it was supposed to do. So the court system is structured in reflection of the way our legal system is structured. And I think we talked about this in, I forget, one of the early chapters, how we have criminal law and civil law. And there are criminal courts and civil courts. In response to that, we're going to primarily talk about criminal courts, but I'm going to mention the civil court system here because it is important. The criminal court does what it sounds like. They deal with violations of the criminal code. There is a higher burden of proof required for conviction in a criminal court, and we've talked about that. It's proof beyond a reasonable doubt. The defendant in these cases is found guilty or not guilty. They're not found innocent. They are found not guilty, meaning there's not enough evidence to prove guilt. And so we're going to find them not guilty. And punishment for or penalties for criminal cases can include incarceration, probation, fines, sometimes capital punishment or death. This is all going to be different than the civil courts, whereas civil courts focus on interpersonal disputes. So people having like a business dispute, landlord-tenant disputes, things like that. Property disputes. So who owns a piece of property, or who should have control over property in a divorce or something like that. Cases of financial loss. So you're in a car crash and the other person's at fault and they don't have insurance. You can sue them in civil court to recover the cost of your damages and injuries, things like that. And so that's what the civil courts primarily focus on. They also are in charge of a lot of juvenile cases because those are not really considered criminal cases. They deal with family law, divorce, things like that, child custody, other things that are not criminal. They all end up in the civil court system. In a civil trial, there is a lower burden of proof, which I think we have talked about this as well, that you have to prove your case by the preponderance of the evidence, meaning there's sufficient evidence to lead a jury to believe that more than likely the the defendant in these cases, is in fact responsible for whatever harm or loss was caused in the action itself. And so in this, instead of a punishment, the defendant is found to be civilly liable and has to pay some sort of restitution or fees or whatever to reimburse the loss that the plaintiff suffered. And so it's a financial penalty. You cannot go to jail or be placed on probation or anything for the outcome of a civil trial. You just have to pay money back, what you owe, what the court determines you owe. Now, one key point that it's not on here, a person can be tried for the same action in both criminal and civil court. So take O.J. Simpson as the classic example. Most of you are probably familiar with O.J., but used to be a famous football player and actor. He was criminally charged with killing his ex-wife and her male friend. I assume they were romantic partners, but we don't know that for sure. But they ended up being murdered outside of her home. O.J. Simpson was arrested and charged with it. He was found not guilty in criminal court, but the families of the victims sued him civilly, and there was enough evidence in the civil trial for the jury to say that by the preponderance of the evidence that O.J. Simpson did in fact cause their deaths wrongfully, and he was required to pay a pretty large punitive judgment against him, which I don't guess he ever really fully paid it off before he went to the great beyond. So we talk about double jeopardy. Double jeopardy doesn't apply in this concept of, or in this case of being taken to criminal court and civil court. double jeopardy only applies in criminal cases. So when we talk about the courts, they have a jurisdiction, just very similarly as the police do. It's just a little bit different. And this is primarily going to be focusing on criminal courts here, but civil courts have a similar structure as well. And there are different kinds of jurisdiction that we're talking about here. So you have geographic jurisdiction, which is what it sounds like, that a particular court is responsible for cases that originate within its geographic jurisdiction, whatever that political jurisdiction would be. It could be a city court, a county court, a district circuit court, it could be a state court, whatever. Whatever that geographic political boundary is that they're responsible for, cases that originate or happen within that geographical boundary go to that court based on geographic jurisdiction. You also have a separate hierarchical jurisdiction, which means that basically there's a hierarchy of courts that run from courts of original jurisdiction, they call it, where cases originally come into the court system, and it moves up the chain through the appellate system to the state Supreme Court, and or it could move to the federal court level where you have the federal district court or the U.S. District Court, then the U.S. Courts of Appeals, and then it may go to the U.S. Supreme Court. But it moves up the line and sometimes back down depending on what's going on. And the two are interconnected with one another, but they are separate in certain ways. Courts also often have what's called subject matter jurisdiction, which means that courts only hear particular types of cases. So one example of this is called a court of limited jurisdiction. These are going to usually be your low-level county courts, city courts, um, sometimes a district court, depending on how the state or the county or whatever sets it all up. But these are the low-level courts where most cases come into those courts. Those are going to be your misdemeanor cases and your traffic violations and ordinance violations, things like that. They do the bulk of the heavy lifting because most of the criminal, charges that come in are going to be misdemeanors and traffic violations, right? Then you have general jurisdiction courts. And these are going to be typically called circuit courts, is the most common reference for them. And these are going to be the courts of original jurisdiction for felonies. So any felony case is going to go to the circuit court, and that is the court of general jurisdiction for that area. And then there are special jurisdictions that hear specific types of cases like family court. So divorces, any sort of child custody disputes or property disputes tied to a breakup or whatever. It could be you have a child who is a chronic runaway or constantly delinquent or deviant, and the parents have to file some sort of out of control charges. That's what they called it in Florida, against the child for the state to step in and help take care of them. Cases of child abuse, child neglect will go to family courts or juvenile courts, either one. Those kinds of things. And juvenile court is another special jurisdiction court that's all they deal with is juvenile court cases, including criminal charges for juveniles, although they're not charged with crimes, they are charged with violations of law. It's a subtle difference, but juveniles are not charged as criminals, they're charged as delinquent, and that's a whole other topic for a different chapter. Anywho, then there are drug courts. This is a more modern evolution, or not an evolution, a more recent creation, where we recognize that putting people in jail for nonviolent drug offenses is not the most effective way of dealing with the problem. And so drug courts were set up to provide an opportunity for drug offenders, nonviolent drug offenders, particularly first-time nonviolent drug offenders, to have their cases heard, and then they would typically be allowed to enter into a diversion program of some sort where they can go to drug treatment. They'll probably be on a probation period with drug testing, things like that. And then if they successfully complete that, then their case will be dropped. But they specialize in those drug cases. Probate court is another one. Probate is not the same as probation. Probation is a penalty. Probate is a civil court that deals with property after a person dies. So if somebody passes away and they have a will, the will has to go to the probate court to be certified, and the judge will then make sure that the property is divided up in accordance with that will. Or if a person dies without a will, then the judge will look at the property and look at the law and decide how that property needs to be divvied up in accordance with the law. So that's what probate courts do. It's not a criminal thing, but it's something that people, you may run across, and I thought you should know. In the state of Montana, we follow a similar structure. We just call it different things. And this is why this can kind of get a little confusing, because each state will talk about their court system in different way with different names, but it's all kind of the same thing. So in Montana, the court of limited jurisdiction is called the Justice Court, and we also have city and municipal courts. And this is where they hear all misdemeanor offenses in the Justice Court. They also hear some civil cases. So civil cases up to $15,000, and small claims up to $7,000, which to me they're kind of the same thing, because small claims is a civil case, but I digress. I'm not a lawyer, so landlord-tenant disputes, any violations of city or county ordinance. So let's say like a noise ordinance, or maybe you have a dangerous animal, like a dangerous dog, and you don't keep it contained and it bites people. They may charge you with an ordinance violation. That'll go to the justice or city or municipal court. If you are in an intimate partner relationship or a family relationship where there's violence and you need to get a protection order, you would go to the justice court. And juvenile cases also go to the justice court. And then for felonies, you have the district courts. They also hear other civil cases that aren't heard in justice courts. And if you are convicted of a misdemeanor offense in justice court and you feel like there was some error in the trial process, you can seek an appeal up to the district court in Montana. Now, in a lot of other states, that would go to the appellate court, but Montana is unique in this regard. And then you go through the appellate process, and you may be able to go to the Montana Supreme Court, which is called the Court of Last Resort for all appeals in a state. The U.S. Supreme Court is the court of last resort for appeals in the United States. But that's kind of how the Montana court system is structured. But the takeaway from this, all of this with jurisdiction and hierarchy, is that you generally have a lower level court that handles the minor cases. You have a mid-level court that handles the more serious cases. You have an appellate, and then you have the appellate system above that that goes up to the Supreme Court. That's basically how it works. Now, outside of the state, you have the federal court system. And this is, to me, a little more cut and dry. You have three main levels here. You have the U.S. Magistrate Court, the U.S. District Court, and the U.S. Circuit Courts of Appeals. The magistrate courts are like the courts of limited jurisdiction at the state level, where they manage the routine day-to-day work of the federal court system. So if you get, let's say you go to a national park, you go to Glacier or Yellowstone or whatever, and you get a speeding ticket while you're there, the magistrate court's going to handle that. If you need to file some sort of motion on a case, it will probably go to the magistrate court. They handle the day-to-day grunt work. The bulk of the actual criminal caseload And this larger civil caseload is going to go to the U.S. District Court, which is more like a circuit court in a lot of states. Um, and then if you, let's say you're charged with a federal crime for bank robbery, and the federal government charges you, your trial, your case will go to the U.S. District Court because it's a felony crime. And if there was a trial, that would all be handled at the U.S. District Court level. You would go in front of a federal judge and a jury, just like you would at the state level. And if you're found guilty, you could theoretically, if there's a legal argument to be made, you could try an appeal, and it would go to the U.S. Circuit Court of Appeals. And there are like multiple circuits across the country that hear cases from a variety of magistrate or district courts in their jurisdiction. And the U.S. Circuit Court of Appeals can also hear appeals from state court cases if there are questions of constitutional law involved. Beyond that, they don't hear any state cases. And then again, the court of last resort in the United States is the U.S. Supreme Court. Their jurisdiction is the entire country and all of our recognized territories. Any cases that there are questions of constitutional law in play, that is what the Supreme Court hears. They don't hear questions about evidence. They don't hear questions about state level law interpretation, things like that. If one can make a sound legal argument that their constitutional rights were violated, that is what the U.S. Supreme Court might choose to hear. The U.S. Supreme Court is also the court of original jurisdiction for disputes between states. And where you see this most common today are sometimes there's a boundary dispute between two states. So, for example, one I know of directly is in between Tennessee and Georgia. There is some question on how the state line was surveyed out back in the 1800s. Well, why are they arguing about a state boundary from the 1800s? It's because of water access. There's a large reservoir there, and it's in Tennessee right now, but Georgia is arguing that the state line was drawn too far to the south and that it should actually be to the north of that reservoir, so that Georgia will then have control over that water supply because they need to send it to bigger cities like Atlanta. So that's a lot of times where you see these disputes between states coming up. The U.S. Supreme Court has a panel of 9 justices. And these justices have lifetime appointments. They are appointed by the President of the United States and confirmed by the U.S. Senate. And once they are there, they serve until they choose to retire. They are completely incapable of doing the job, and they can be removed. They can be impeached for misconduct, or they go to the great beyond. Those are the only ways that you get a U.S. Supreme Court justice out of office. And this is also the same case with federal judges in general. So if you appeal a case to the U.S. Supreme Court, there is a strong likelihood that they're not going to hear it. There are around 7,500 requests per year. The court gets to pick and choose the cases they want to hear, and they only hear around 125 per year. The estimates I see usually say around 100 to 150, depending on what they want to do. And you will request this. It's called a writ of certiorari. It's a document, a legal document that you submit to the Supreme Court, in which you lay out the facts of the case at hand and the legal question regarding constitutional interpretation that applies in this particular case. The Supreme Court has a panel of legal assistants who are attorneys who filter through these, and the ones that appear to have higher levels of merit will then get filtered up to the justices, and they can pick and choose the cases they want to hear. If they grant certiorari or agree to hear your case, the parties involved, it's usually going to be a state prosecutor or a state attorney general, something like that. And the defense will present legal briefs, making legal arguments about the question at hand. So it could be, was an unlawful search and seizure, and so they will go through the process of arguing the law related to search and seizure in that particular case. Um, Supporters of each side can submit what are called amicus curiae briefs, and they are basically similar legal briefs or arguments in support of one side or the other. Amicus curiae means friend of the court. These briefs don't really have any particular weight. The justices can choose to read them, they can choose not to. Um, but basically, it's an opportunity for other parties who feel they have some interest in the outcome of that case may present their amicus curiae brief to the court in hopes to sway their opinion one way or the other. Once all this happens, the two parties are going to appear in person in Washington, D.C. for the oral arguments, and they have a specific period of time. I forget what the time limit is. It's not an extraordinary amount of time, maybe 30 minutes or something, to make an opening statement, and then there will be a question and answer session between the justices and the prosecuting party, the state's attorney, or whoever represents the interests of the government, and the defendant's attorney. They will have question and answer as well. Following those oral arguments, the justices will end up meeting in private, and they'll make a decision, issue a ruling. This can take weeks or months for them to do this. They will issue the ruling at some point, and in it, they will make a legal statement about the outcome of the case, and it's supposed to be based on the idea of precedent, which we have kind of talked about before. But it's the idea that once a legal decision has been made, that interpretation of the law should stand and be applied again in the future. And you will have a majority opinion that will lay out the arguments of why the court chose to rule a particular way. Then there will, if it was not unanimous, then you will definitely have a dissenting opinion, which are the people who disagree with the majority, will make their arguments on why they didn't think the case should have been ruled that way. And sometimes you'll have what's called a concurring opinion, where there are justices that may agree with the majority or the dissent, but the perspective of why they should have ruled a certain way, but they have a different legal argument for why they should have ruled that way. Hopefully that makes sense. But basically what you need to know here, beyond just the general idea of how the court works, is that just because you think you have a reason to go to the U.S. Supreme Court and have them hear your case, it's unlikely they're going to hear it. Because you figure out of the millions of cases that happen, criminal cases that happen every year, only 7,500 even get sent to the Supreme Court for consideration, and only 125 a year are heard. So now moving past the structure of the court system, I want to talk about the courtroom itself. In the courtroom are a group of people that scholars generally call the courtroom work group. And the courtroom work group basically, from an academic standpoint, includes any person who has some legitimate business or dealings with the court at any given time. The primary members of the courtroom work group are the judge, the prosecutor, the defense attorney, and the jury. All right. There are a variety of other people who are tied to the court case in some way. Particularly if there's a trial, they may be responsible for certain roles. So like the bailiff, or the person that provides court security. You're going to have court clerk staff, which are administrative people who work in the courtroom with the judge, keeping track of paperwork, swearing in witnesses, things like that. You will have a court reporter, somebody who will maintain an accurate record of all of the statements made in court from both sides. Traditionally, you'll see the person sitting in front of the little miniature typewriter typing away. That was called a stenographer. Now court reporters use more modern technology, usually recordings and computer keyboards and whatnot, but it's the same process. So that if you go and pull up a record of a case, you can actually get a word for word transcript of the conversation that happened in the court. Um, there are going to be potentially witnesses involved, perhaps victims involved. There may be correctional officials involved, particularly from probation and parole, who may do pre-sentence investigation reports, things like that. There may be members of the press that are present, and there may be members of the public. The court hearings are generally open to the public. You can go to a court hearing or trial anytime you want to. And they do that for transparency. So that way there's no question that what's going on in the courtroom. Now, for our purposes here, the biggest thing that you need to understand is that these three main figures of all these people that are in the courtroom, and I promise you, this isn't, I hope it's not, you don't think this is quite as complicated as it looks on paper. You have the judge, the prosecutor, and the defense attorney. Those three people are the main figures in the courtroom. All right. And the way the court system is philosophically set up, each of these individuals is an independent member of the courtroom work group with a separate role to play in the trial process itself. And so the prosecutor represents the interest of the state, and the defense represents the interest of the accused. And as we talked about before, those two are engaged in an adversarial process, competing with one another, guided by due process, the law, and armed with facts and evidence, right? The judge in this case is supposed to act as an independent individual who is basically a referee over this competition to make sure the rule book is followed. The rule book being procedural law and the statutory law as needed. All right. Within this, the justice is measured by the process itself, as I talked about before. We do justice under this model, and the emphasis is placed on due process rights and the assumption that the accused is innocent until proven guilty. Okay? In reality, what tends to happen is what you see on the right. The court ends up acting more like an assembly line that processes cases through efficiently. Under that model, justice is measured by the outcome. Do they get a criminal conviction or a guilty plea or not? And if they do, how quickly and efficiently are they able to process this through? And the tendency here is to assume that people are guilty. They wouldn't have been arrested and charged by the police if there hadn't been sufficient evidence that they did something wrong. They wouldn't have been indicted by a grand jury. The prosecutor wouldn't have brought charges, whatever. And so if the assumption is you're guilty, then we want to get this case adjudicated as quickly and efficiently as we can. And that's why we rely so much on plea bargaining, where the defendant is offered a deal by the prosecution for a reduced sentence or whatever in exchange for a guilty plea. And when the system is set up this way, the three members of the courtroom work group tend to come together collectively as a singular unit, working in the courtroom, working towards the process of reaching this outcome efficiently. And so the prosecutor then takes on the role as an extension of the police. The police have made the arrest or the criminal charge. Now it's the prosecutor's job to get the conviction. And the defense attorney, who's usually burdened by a heavy caseload and shared interests of this courtroom work group, will encourage the plea bargain to get the case processed. And the judge primarily will act as a timekeeper in this process, because the negotiations for pleas between the prosecutor and defense are done behind closed doors. The judge doesn't have any interaction with that. So what the judge ends up worrying about is, when are the hearings scheduled? When are the plea negotiations scheduled? Is there going to be a plea deal? And when is it going to be presented to the court so they can keep the calendar and keep the schedule moving forward? All right. Within this dynamic, the prosecutor holds the most power. There's a tendency to assume it's the judge because the judge is the symbolic figurehead who sits on the bench above the courtroom in their black robe with the gavel and controls everything. But again, they're really just a referee. So think about a football game or a soccer match or a lacrosse game or baseball or whatever. The officials, the referees, the umpires, whatever, they're not the focus. They are kind of in the background orchestrating the process, making sure it goes smoothly. The real players are the ones on the field doing the playing itself. And the prosecutor in this process has the greatest amount of power. So ponder, why do you think that is? What is it about the prosecutor that makes them so powerful? Well, it comes down to the topic of discretion. The bulk of discretion in the court process, in the adjudication process, lies with the prosecutor. Okay? The prosecutor gets to pick and choose whether to charge somebody in the first place. Just because the police arrest you doesn't necessarily mean you are going to be formally charged in court. You probably will be, but you don't have to be. The prosecutor can choose not to bring formal charges and let it go. The prosecutor ultimately decides what the charge is going to be. If you're arrested, the police may charge you on paper with possession of, drug paraphernalia or whatever, and possession of methamphetamine or whatever. The prosecutor may choose to drop one of those charges and keep the other one. They may amend it to something else. So ultimately, what you end up being formally charged with in court is going to be up to the prosecutor. The prosecutor gets to decide whether to engage in any sort of plea bargain process at all. If the prosecutor chooses to offer a plea bargain, they can do that, and more often than not, they will, but they don't have to. And within all of that, they get to choose what punishment to seek. It's guided by statute. There's a statutory maximum and statutory minimum in a lot of cases. But the prosecutor gets to decide within that process what they're going to ask for or what punishment they're going to offer in the plea deal. And so all of this is in the hands of the prosecutor, who does a lot of this behind closed doors. It's not an open court. It's not directly regulated by the judge. And so the prosecutor has this control. And a lot of times you have the juries and the jury process, but most of the time the court case never makes it that far because the prosecutor pleads it out. Well over 90% of cases are pled out in court, or pled out through the plea bargain process outside of court. That's what I'm trying to say. But on the offhand chance that the defendant chooses not to accept the plea, or that the prosecutor chooses not to offer a plea, or they can't reach an agreement, then it may go to a trial with a jury. And trial by jury is guaranteed by the Fifth and Sixth Amendments of the Constitution. And there are two types of juries. You have grand juries and trial juries. And I'll talk about each of these in a second. But these juries are supposed to be made up of a jury of your peers selected from the local community. And the idea here is that you are a member of the community, the court represents the interests of that community, and the jury should be made up of a representative body of people from that community who can make interpretations on how they want to apply the law in any particular case, right? Now, you have a grand jury. The first type here is called a grand jury. It's also called the court of inquiry. It is a special jury that's held by the prosecutor to only hear evidence of felony cases. All this grand jury is going to do is hear evidence in criminal cases and decide whether or not they believe there's sufficient evidence to justify formally charging someone with a crime. And it's the prosecution brings in witnesses, they bring in evidence and present it to the grand jury. There is no participation by the defense. That comes later on in the actual trial itself. All the jury deliberations are in private, and if the grand jury believes there's enough evidence to justify the charge, they'll issue an indictment. And this indictment is the official charging document in felony cases most of the time. Once you've been indicted, or let me get this last point here. Jurors are selected from the local community, serve as needed for a period of 1 year in Montana in federal courts. That's pretty typical across the board. 6 months, a year. You don't meet every day, you meet as needed. So you are serving on the grand jury. You may get a grand jury summons from the prosecutor for a certain day or 2 days or whatever. And you'll hear a case or multiple cases, and then they don't need you again for a while. Once that indictment's happened, you go through the pre-trial process, all that stuff. If there ends up being a trial by jury, then a trial jury will be chosen to hear your case. They're also called petit juries, and they're tasked with hearing evidence in open court to determine whether you are guilty or not guilty. Typically consist of 12 individuals who agree unanimously on a verdict. The verdict is guilty or not guilty. And so these jurors are going to be selected through a process called voir dire. I forget what voir dire means. It's a Latin phrase. But it's a process where the prosecutor and the defense participate in picking the jurors through kind of like a give and take, back and forth question and answer session. And the judge oversees this process to make sure it's done fairly. And these jurors are selected from a jury panel, or called a veneer, that's usually compiled from voter registration lists or driver's license records. I think the more common one now is driver's license, because more people have driver's license than are registered to vote. But they'll pull this random list up. They will then pick a random grouping of people from that list. You are then on that jury panel. You are brought in. You sit in a courtroom or in a jury selection room and go through this Q&A process. And the defense and the prosecutor work together to decide who to keep and who to excuse. Now, if you're chosen or brought in, you can request to be excused if it's a hardship. If let's say you've got kids, and you can't find anybody to take care of your kids, or you've got medical issues or whatever, you can make a request to be excused, and a lot of times they'll let you go. Beyond that, you can be challenged for cause. So let's say the defense doesn't like a particular juror because of something they have said or an attitude they've expressed, some relationship with the police or whatever. You can be excused for that. There has to be a legitimate reason for, your removal based on challenge for cause. There are also preemptory challenges where the prosecution and defense can just exclude certain jurors for whatever reason they feel like, but there is case law that ruled that jurors cannot be excluded based solely on race or ethnicity. And the reason this exists is particularly in the South. There was a tradition of all white juries, even though there's a pretty significant black population in the South. More often than not, these jurors would be, these potential jurors who were black would be excluded. And then you would have black defendants accused of crimes that were being judged by an all-white jury. And particularly, it still exists today, but particularly back, throughout the 20th century, racism was pretty prevalent in the South. And so the argument was made that a black defendant couldn't get a fair trial if it's an all-white jury. And so this Batson case ultimately ruled that you can't exclude jurors based on race or ethnicity. Once this process happens and the jury is selected, then the trial can happen. So now I want to talk briefly about the stages of the court case itself. So there's the pre-trial phase, the trial phase, and the post-trial phase. And I don't think this is laid out in your book quite this in detail, but I thought I'd talk about it. I'll go through it pretty quickly. You don't need to memorize this. So in the pretrial phase, the defendant goes to what's called first appearance, and that's where they're notified of their charges. And there may be a bail determination, whether or not they need to post bail to be released prior to trial. They can also be released on their own recognizance. If they believe that you are likely to show up for your trial or answer the charges later on, they'll release you. It's called ROR. Or if they feel you're a flight risk or you're a danger to society, they can hold you for preventative detention to make sure you can't harm anybody while you're out. Once this happens, there will be a question about whether you have retained a defense attorney or not. If you have not had one, they will arrange to have a defense attorney appointed for you. So your first appearance, you don't have to have a lawyer with you during this. All they're going to tell you is say, this is what you're charged with. This is our bail determination or release. Do you have a lawyer? And if you don't, we'll get you one, kind of thing. After that happens, the prosecutor is going to end up reviewing the charging documents later on and look at the evidence and decide whether or not to formally go through with the prosecution. If they do, they'll file a document. It's called an information. And the information is the formal charging document that goes to the court saying this person is being formally charged with these crimes and here's the evidence, basically. If the prosecutor chooses to not prosecute, they'll file what's called a no information and the case gets dismissed. Once that formal thing happens, then you are now arraigned. You are brought in, given your formal charges, and you are allowed to enter a plea. You will have a lawyer by this point. The lawyer is going to represent you in this arraignment, and they're going to tell you to plead not guilty. It's normal. It's the way of doing things. I hear a lot of people complain about that it's like, well, the person's obviously guilty. Why are they pleading not guilty? Because that's how the system works. It's supposed to give time for the prosecutor, or I'm sorry, for the defense attorney to look at the case and do what they need to do with it. After that not guilty plea is entered, then you go through the pretrial phase, and this is where all the background stuff happens. So the defense may file pretrial motions, like a motion to suppress evidence that was illegally obtained or whatever. There's probably going to be depositions taken where the prosecutor and the defense have opportunities to interview witnesses and things like that. At some point, the prosecutor will probably offer a plea deal, and there will be those negotiations in the pretrial phase. The accused may choose to agree to that plea bargain and plead guilty. In some states, there is a nolo contendere plea, which is no contest, which you're not admitting guilt or innocence, but you're accepting the punishment anyway. And there may also, in this process, the case may end up being dismissed. So let's say through pretrial motions and depositions, we find out that the prosecution or the police falsified evidence or made an illegal search and seizure and the evidence is now gone. They'll just choose to dismiss the case because they don't have any evidence left. And if it goes far enough, this is when jury selection takes place. If the case actually goes to trial itself, they will appear on court day. The judge will be there. All the others of the courtroom work group will be there. And the prosecutor and the defense will offer opening statements. They'll basically outline the basic argument behind their position in the case. The prosecutor goes first. They will then bring their witnesses and evidence. And there are two types of evidence that are going to be brought in. There's going to be direct evidence and circumstantial evidence. And direct evidence is any evidence that directly connects the suspect or the defendant to the crime itself. Okay? So, like fingerprints or DNA, they're clearly attached to the defendant. That's direct evidence. But there's also going to be circumstantial evidence. And there's a tendency, in my experience, for people to consider circumstantial evidence as not real evidence, not true evidence. So it's like, oh, well, they couldn't get a guilty verdict. It was totally a circumstantial case. In reality, the circumstantial evidence is the important stuff. Okay? Just because your fingerprints are at a crime scene doesn't mean you committed the crime. It just means you were physically present, or that your fingerprints were physically present at the scene at the time the police got there. Okay? Think about if you're sitting in a classroom on campus and you leave class, and after class, a student or me, we'll go with me, I'm murdered in the classroom after you all leave. Police come in and do their search for evidence. What are they going to find in the room? They're going to find your fingerprints, all of y'all's fingerprints, and all y'all's DNA are probably going to be found in that room. What's important is the circumstantial evidence. What are the circumstances that explain why that evidence was present? Okay? The circumstances were, well, you all came to class. And of course your DNA or fingerprints are going to be there because you were physically in the room for a legitimate and lawful purpose. That doesn't mean you committed the crime, right? And so the circumstantial evidence is the information that creates the story, that puts the physical direct evidence into proper context and how it proves guilt, right? Or innocence in the case of the defense. So don't discount the idea of circumstantial evidence as unimportant, because it's really probably more important in a lot of cases than direct evidence. Once the prosecutor presents their witnesses and everything, the defense gets to cross-examine those witnesses to try to poke holes in the prosecution's case. At the end of all that, the prosecutor is going to rest their case and saying they're basically done. At that point, the defense is going to stand up and make a motion to dismiss the case due to lack of evidence. It almost never works, but it's one of those procedural things that defense attorneys are obligated to do ethically. And it's my understanding that in some states, if a defense attorney doesn't do that, they can be disbarred or removed from the legal profession for not providing a sound defense for their client. So again, people get heartburn over this, but it's just part of the process, okay? Once the judge overturns that motion, then the defense gets to go. And they're going to present their evidence. They're going to present any witnesses they have in their defense. They're going to present any exculpatory evidence, which is evidence that tends to disprove the guilt of the defendant in some way. So alibis or alternative explanations for why direct evidence may be at the scene or whatever. There may also be mitigating evidence, so that if there's not much question that the person did it, the circumstances surrounding why they did it may be important, that make it less serious. So for instance, if you kill your significant other because you caught them cheating on you with your best friend, and you flip your lid and you kill him in a fit of rage and passion, that is going to be different under the eyes of the law in most jurors' minds than if you chose to kill your significant other for insurance money, for greed. Those are two categorically different things in a lot of people's minds. That's what mitigating evidence might be. The prosecutor also gets to cross-examine those defense witnesses. At the end of all this, both sides will present closing arguments, and then it goes to the jury. The judge is going to provide jury instructions on what the law says, what they're required to consider, and they will send the jurors off to an ante room or a jury room to deliberate in private. And those jurors are not allowed to have contact with anyone outside that room other than the trial judge, and most often that is only done through the process of providing letters or written documents back and forth. The judge doesn't go in and talk to them directly. The jurors can return one of three verdicts. It's going to be either guilty, not guilty, or they're going to have a hung jury. They're not able to reach a unanimous decision. They're deadlocked, and the judge will then declare a mistrial. Okay? There are cases where jurors will return a not guilty verdict even when there's clear evidence to support a guilty verdict. This is called jury nullification. This used to be really problematic in the South, again, back in the 1800s and earlier through the 20th century, when you would have like black people who were murdered, or black civil rights workers, or people, volunteers who were murdered by like Klan members and things like that. You'd have an all-white jury, and a lot of them were in the same social circles as the defendant. And even though there was overwhelming evidence they'd committed the murder, the jury would find them not guilty anyway. It's called jury nullification again. Another other times it's done symbolically. There has been some argument made that the OJ case again, that criminally there was enough evidence in that criminal case, but that the jury chose to find him not guilty anyway through jury nullification to make a symbolic statement in protest to the police. So it's not illegal to do that. It doesn't happen a lot, but it happens. It can happen. If the jury does reach a guilty verdict, the accused is typically remanded to custody at that point, and they will be held until sentencing at a future date. There are times when the defense can make a motion to have the person released prior on bond or whatever prior to sentencing. Sometimes that happens, sometimes it doesn't. Once the sentencing comes along, um, the judge is going to determine this defendant's sentence. There's going to be a pre-sentence investigation done by the probation and parole office that lays out all the factors related to the suspect's criminal history, their mental state, their resources, their life circumstances, things like that. The judge will then refer to that. They will also refer to any statutory sentencing guidelines in place that mandate particular length of sentence. And the judge will then decide that sentence. In some states, the jury does have some input. In a lot of states, the jury does not. This is solely on the judge and the prosecutor to make these decisions. If the jury does have input or does decide the sentence, the judge oversees that process, and the judge can intervene and or disregard the jury's decision if the judge feels it's inappropriate. In a capital case, it's a little bit different. There's a separate sentencing phase of the trial where a jury will then hear the facts of the case again and decide whether the death penalty should be given or not. But that's only in death penalty cases. And then at final sentencing, the judge will advise the defendant of the punishment imposed. If it includes carceration, the suspect is immediately put in cuffs and taken off to jail. If they're released on probation or whatever, they get to go home, but they have to report to the probation office. And so that's kind of how the process works. Now, after that, there could be appeals filed. And this will be on the part of the defendant. Well, even the prosecutor can file an appeal. If one of them argues that the trial judge made an error in the law, usually something like allowing certain testimony that shouldn't have been allowed, or allowing a particular witness that was prejudicial or shouldn't have been allowed to testify, or that there was questions about the legality of evidence and the judge allowed it to be admitted instead of excluded, things like that. They can argue, make a legal argument about error in the original trial process, and they can file an appeal in the appellate court. The burden of proof in these lies on the person bringing forward the appeal. So if the defense attorney says that their client was wrongfully convicted because the trial judge allowed illegally obtained evidence to be introduced in trial, it's up to the defense attorney to make that argument and prove their case, basically, in that appeal. And the prosecutor may be the opposite. It would be, they shouldn't have allowed some expert witness on the defense to be able to testify, or some evidence was excluded that shouldn't have been. The prosecutor has to make that case, and the defense gets to argue against it. Once this happens, or if this happens, again, the parties submit legal briefs. They may engage in oral arguments depending on how the system is set up. And the appellate court may overturn a conviction because of this. They may return the case to a lower court for a retrial or resentencing. Um, they may, more often than not, they may rule that, okay, there was a procedural error, but it wasn't significant enough to change the outcome of the case, and then everything stands as it is. Through this process, you could theoretically move it all the way up to the Supreme Court under certain circumstances that I've already talked about, but that's kind of how the appeals process works. With the exception of capital cases, you do not automatically get an appeal. You have to have a legal justification to ask for the appeal, basically. So that's kind of the down and dirty of the U.S. court system and the trial process. I hope that was not too overwhelming or confusing. And I don't expect you to know it in the level of detail that I talked about it. So if you have any questions, let me know. And we'll move to chapter 10 on sentencing next week.